Hey, Kurt, how's it going?
I feel very conspicuous.
Sorry. Whew. How's it going?
5 minutes with friends is better than 5 minutes without friends. So as long
Heck
as the
yeah.
stream lasts, it's fine by me.
Yeah, absolutely. So I don't know. Did you catch the complaint at all or no?
No, I was watching a little bit of Andrew Branca because he's in my neck of the woods and just checking out his stream.
Okay.
And then I
So
saw you were still streaming. So
yeah. So basically, this comes down to they are alleging intentional infliction of emotional distress against Brian Laundrie's parents. They have alleged, and I'll go through just
how?
Yeah, right. Yeah, that's the question.
How?
It's a good question.
What is the central theory of the case?
The central theory of the case is the Laundrie parents knew on August 28th that Brian had murdered Gabby. They then hired counsel right away. And then they could have given information as to Gabby's whereabouts or the whereabouts of her remain, but chose not to. And they knew that doing so would cause great emotional harm. And it did, in fact, cause great emotional harm.
That's a fail.
Yeah.
That's a fail.
I agree.
Yeah. Intentional infliction by me not doing things without an affirmative duty, which I don't have.
That's what I said.
It's a total. Yeah. I mean, it's nice when we come up with the exact same answer, right? It's like it's a total fail.
Yeah.
Give me a harder one next time.
Yeah. As I was going through. So that's why I said that this as far as meeting the requirements of a motion to dismiss, I think that this survives a motion to dismiss, but I don't think that it's going to get much further beyond that.
Well, I'm not even sure about that. How do you think it survives a motion to dismiss when your central claim doesn't make sense? Because like I didn't do a thing. I wasn't required to do a thing. End of analysis. So how do you survive a motion to dismiss?
It's just the defendant. So there's 4 elements. You have to show that the defendant did something.
Which
number 2
is a fail.
Well, an omission is an act as well.
It can be, but only if you have some sort of duty, obligation, responsibility to act, right?
No, not in this case. No, because we're not talking about negligence here. If we were talking about negligent infliction of emotional distress, yes, we would have to add in an analysis of a duty. But I think that in terms for purposes of an intentional infliction of emotional distress, I think that in whether it's an act or an omission, I think that it checks the box.
Okay, carry on.
So number 2 is the defendant's conduct is outrageous, and it has to be obviously objectively outrageous. Now, they've alleged that it is. I don't think that they can prove that it is.
Carry on.
Number 3, the defendant's act for the purpose of causing the victim emotional distress so severe that it would be expected to adversely affect mental health. So with the purpose of causing. So what they said that they did so with malice or with reckless disregard, which I think that in Florida that probably is, without doing Florida research, my guess is that they probably have a recklessness standard that survives in for the purpose element.
Oh my God. I'm just looking at the chat and now there's some it just goes my hatred of StreamYards and all these platforms. Jay Thompson says your audio sounds soft, muffled, and quiet, and I just want to commit Harry Carey. I'm trying to do some analysis. Yeah, my audio's a little soft. Will you want me to turn it up again?
I turned yours up. Don't worry, I turned yours up already. It was way low from our earlier live stream. Mine was too at first.
My desire to kill is increasing. What's the fact? Okay. What's the 4th factor in this analysis?
The 4th is that it caused emotional distress, which they allege, and that probably is the strongest element that they have. Of course, there's emotional distress in spades, and of course, if the defense were to fight against it, they could also fight against that element to say you already had emotional distress because of the fact.
Yeah, I mean, you can fight it on all 4. For me, it's just a total fail.
Of course,
it's like
I think that's why I think
it's a fail. It's a fail through and through. It's.
Yeah.
I didn't have any particular obligation to tell you that I had this information. I hired a lawyer, which I have every right to do in the world. So like, you hired a lawyer immediately.
Mhm.
This like benching, that's a total non-starter. Um, and I did it with some sort of purpose as opposed to like protecting. No, this is a non-starter. I don't think
Yeah,
it survives a motion to dismiss. I'm throwing it
I
out.
I think it survives a motion to dismiss, but just barely. Just because
Hmm.
it's such a low standard. It is such a low standard, believe me. So
But
I
it is
think
IIED, and courts do tend to look at that a bit skeptically, as I'm sure you know.
yeah, they do. They do. But I still think that this is probably enough.
Okay. Want to put a
So
fiver on it?
a fiver? What do you
Yeah.
mean?
But you
Oh,
$5.
a $5 bet?
Yeah.
$5 super chat bet?
Yeah.
Let's do it.
Okay. One
Let's
of
do
us
it.
is to admit the other one was wrong. Or right,
Sure,
as
that's
the
fine.
case may be. Fair enough.
Sounds good.
Five
Sounds
dollars
good.
super chat on the who was
That
right
sounds
on
good.
that
Yeah.
one.
Let's bet a $5 super chat on it. That
Okay.
sounds good.
All right. That sounds fun.
Yeah. But I do think so. I think that this is probably just enough to get into discovery, and I think that that's probably as I was sort of working my brain through this live, I was thinking that I think that probably is the reason why they filed it, is just so that they can get access to information, so that they can get closure.
What do you think is theoretically discoverable? What do you think is the best case for discoverable stuff?
I think that something well, I mean, first off, talking to the parents, there was a whole paragraph in there about how the Laundrie parents instantly iced them out, both blocking their calls on through direct calls and by blocking them on Facebook. So, number one, being able to depose them. Number two,
I still don't have to talk to you. I have to talk to your lawyer, which is distinctly not the same thing.
well, but you still get to have questions asked of them, and they have to answer. So then
Yeah,
also,
okay.
but I think most maybe most material is they probably want to see the journal that he wrote in, where he supposedly admitted to murdering her.
Which became their property upon his death. So
I mean, probably, yeah. Yeah,
yeah.
they would have, because he was living with them at the time. So they would
Yeah.
have that would all be in
Intestate
their
succession, right?
custody. Yeah. Yeah, you could say.
Should we break out the table of consanguinity? I don't think we need to do it for Paris.
Basic chattel. Yeah, he and Gabby were not married, and they did not have any children, so it goes up to the parents again.
Yeah.
Very very quick intestate succession. So
yeah, all right, okay. So they'll get the journal. Okay, fine. Yeah, they can get the journal,
and probably text messages, because phone logs between the two, so that they can see when when he called them at one point. And then the question, actually, and as I'm thinking through this further, this could become something for the, actually, well, I don't know. What kind of liability could the attorney be facing? I don't think so. He was just hired as an attorney, and he's definitely not obligated to give.
Conspiracy to engage in the IID because he knowingly and purposely advised his clients to withhold that information. I know that. Accessory.
No way. That's not a thing. Every single lawyer would be.
I'm well aware.
So, yeah, I mean, unless there was some sort of they didn't have any duty to give any information, because, like I said, he was a person of interest, right? He wasn't even.
I'm not 100% sure. Yeah, I don't know really how much it really gets them in the end is sort of where this all goes, because no one denies that. No one's at this point denying that he committed the murder.
Mm-hmm.
And unless the parents knew in advance, and you can get them in some sort of criminal posture because encouragement, you can get the parents for conspiracy or accessory or something before the fact. But if they only really knew after the fact or something, it's like, you probably know everything. You probably know everything that everything says without ever looking at it. Like, you can make a pretty reasonable guess. Like, you just use your worst case scenario, and you're already there. Okay, it's like, yeah, okay. So the journal says everything you think it says. The text messages say everything you think it says. These back and forth. And in light of those text messages, the parents clammed up, hired lawyers, disconnected because obviously they didn't want to say anything because their lawyer told them to shut the hell up, as you or I probably would tell them, shut the hell up.
Right.
Should I take this call from this person? That sounds like a fucking bad idea. Don't do that.
Yeah.
As if I'm their attorney.
Yeah.
So let's not do that plan. So it's like, I just don't know what you're really getting out of it. It'll just confirm everything you think is already true anyway. So what's
Which
the point?
maybe that's what they need. Maybe that's because what I was saying before you came on is that there wasn't even a criminal trial in this case for a pretty horrific murder of their daughter.
Well, it's a little hard to prosecute.
Well, of course, and I'm not blaming anyone for that, because the prime suspect offed himself. So
the prime suspect being dead does somewhat preclude a criminal trial.
Of course it does. So, but then you don't get to have a jury of your peers determine that your daughter was murdered by someone. And I can understand why that just it would be so hard to move from, because you don't necessarily get closure, I think.
I mean, I couldn't say what I would do in that situation if I were the parent. Although, me being a lawyer and defensive minded, I probably would be more inclined to go along the same ones as Laundrie's parents, I would think. I mean, I wouldn't know. I mean, if it were your kid and they came to you and said, "Hey, by the way, Mom, just off my girlfriend over here. I just want to let you know about that." How do you think you go about that? Do you tell the other parents?
Shut the F up.
Do you tell the other parents about it? Do you tell the other parents that I know about that your daughter's dead? Do you?
No.
Yeah.
Because then of course, if you then go and say, "Oh, this is where I think your daughter where she is, where her remains are," how the hell are you going to find that information? It's pretty quick. People realize pretty quickly where you got that, right? Like, you weren't there. You were on the opposite side of the country.
That's where I tell my kid to pay me $1 so that he can hire me as his lawyer, so that he'll have privilege.
Yeah.
Yeah, that's good times.
Yeah. So the results of the poll, I asked, do you think the Petito parents have a good case for intentional infliction of emotional distress? 61% said no.
Not a chance in this world.
38% said yes.
No, not a chance in this world.
Yeah, I don't think so.
Intentional infliction, the key word is intent. I intend to inflict. It is I am trying to inflict. And you're more than anyone can bear. And I can't think of, I'm going back in my mind to law school, but I can't remember any IIED cases from lack of action. Can you? It was the IIED case was always, you go up to a woman with a child, for a fact her child isn't dead. You tell her child is dead. That's IIED.
I don't know. See, I could see a situation like, let's say, I'm just pulling this off my head, but let's say you're mad at somebody and that they require, what's that?
I'm mad at StreamYards. Does that count?
Okay. Let's say an individual. Okay. Let's say that there is an individual that in your life that requires insulin shots, and they are unable to get those inject those shots for some reason, and you are the only one that can do it, and you decide, I'm so freaking pissed at this person, I'm gonna not do it.
If I don't have a duty, if I don't have a duty, I can literally watch you drown in a lake and do nothing.
Let's say you
as you're slowly going below the waves of the water, Legalbytes, I can sit there eating my popcorn.
Well, that's true. Yeah, I know. I'm trying to think of some hypothetical situations with omission and where that's successful. I still think that it's enough to allege it, because you could at least try to make an argument for it.
Okay. Well,
I don't think it's going to be successful.
No.